Hey folks, we're continuing our videos on the Constitution and the Bill of Rights this week with the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense twice be put in jeopardy of life and limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So largely this Fifth Amendment has enjoyed more protections than it has infringements, and we're going to cover both of those today. Now, I know there's lots more than the ones I'm going to mention, but these are the ones I felt were pivotal to how the Fifth is applied to our society today. The first is Griffin versus California. And in that case, the Supreme Court decided that court officers may not infer your guilt upon insertion of the Fifth Amendment. So say you plead the Fifth, the judge, your attorney, their attorney, the stenographer, the bailiffs, nobody can infer to the jury that you're guilty because you did that. Nor can they infer that you're innocent either. As soon as you mention the Fifth Amendment, that line of questioning is closed to you, where you're concerned. Now they can pursue other witnesses about that, but they can't compel you to be a witness against yourself. In 1966, there was the case of Schmerber versus California, and I probably butchered that pronunciation. I apologize to whoever might be offended that I did. And that case was a situation where a gentleman had caused an accident because he was under the influence of alcohol, and he killed somebody. And police officers at the time, back then I think they were the California State Police. I don't know if they were called the Highway Patrol yet. They might have been. I don't know. I wasn't around at that point. They wanted to collect blood evidence, and the individual in question didn't want to give blood. The investigators took blood anyway because they felt that the natural course of metabolization would diminish or destroy the evidence, because alcohol breaks down over time in your blood and you become sober again. Nobody stays drunk. So the Supreme Court heard the case and ruled that it was totally constitutional to do that because they're preserving evidence and preserving your right to a fair trial. Whether or not your trial goes in your favor doesn't dictate whether or not it's fair. In 1969, you had the case of Benton versus Maryland, and that was a Supreme Court case where they ruled the Fifth applies to all state courts, so that no state law may compel you to testify against your own interests, and there's no double jeopardy. It strengthened the no double jeopardy clause. You can also see Maryland versus Hogan is another case that covers that same thing. In 1970, you had the case of Williams versus Florida, and it was a case in which the court held the Fifth does not entitle a defendant in a criminal trial to refuse to provide details of his alibi witnesses. To the prosecution. It also says that a jury doesn't have to be 12 people in special circumstances. In 85, you had the case of Heath versus Alabama, which established that the double jeopardy clause does not apply when one state wants to prosecute in a case where it was also prosecuted in other states. So say I go to Alabama and I kidnap somebody, and I drive to Tennessee and I kill him. I'm arrested in Tennessee. The state of Tennessee has the right to prosecute me for the crime I committed in the state of Tennessee. But since the crime started in Alabama, the state of Alabama has the right to prosecute me as well. That's that law. Now the last one is Hayes versus Voigt, and what that was is it clarifies the fact that intimidation is not a violation of the Fifth Amendment, because you still have the right to not say anything, even if they're intimidating you. So saying that they threatened my family, they threatened my kids, they said they'd take my home, blah blah blah, isn't a violation of your Fifth Amendment. It sucks. It's a completely a-hole thing to do, and no prosecutor should do it, but you still have the right not to say anything, so it doesn't violate your Fifth Amendment. Now, on the infringement side of it, there's a couple things I feel our rights have been infringed by. The first one is current child support laws. I believe every father or mother should help take care of their child. I believe that. It's just a natural course of things. Sometimes it can be financially hard on families because just because one family ends in the most basic sense doesn't mean those people go on and don't have families elsewhere. Okay. That being the case, I had previous relationships. I'm married now for 12 years. We have 3 kids. I pay what I can to support my other children. The courts have been very reasonable in that they recognize I have a family now, and it's not okay to diminish my family by making me pay an exorbitant amount to take care of another family. Where child support laws are problematic, though, is the issue of paternity. States have been allowed to run ramshackle over men for paternity issues for the last 25 years. Some states can declare paternity when a test hasn't even been done. All a woman has to say is, "You're the father." And that state can go all Maury Povich on you, and bam, you got 25% of your paycheck being taken every week. That's problematic at best. I understand that we need to establish standards that keep children comfortable and their well-being taken care of, but we can't violate on other people's rights to do that. Just because someone says he's the father doesn't make it always so. I believe personally there should always be a paternity test to declare whether or not there's paternity. Period. Until there is clearly legally proven paternity, nobody should have child support taken from them for any reason. Period. Secondly, there are restraining orders. And I'll do another video to get more in depth about restraining orders. In this case, I'll keep it real short and simple. Somebody feels like, say my neighbor, whose dog keeps taking a dump on my lawn, feels like I might kick his ass. So he goes to the local sheriff or police department and says, "I'm afraid he's going to kick my ass." Okay, he files a report, and then he gets to go to a judge and say, "I'm afraid I might get my ass kicked." The judge says, "Okay, well, I'm going to give you a temporary restraining order." And at that moment, police officers come to my home and serve me notice that I've been given a restraining order. And my Second Amendment immediately goes away. All my weapons are seized right then and there. I have not been convicted of a crime. I have not been able to face my accuser. But my guns are taken away. In some cases, my employment goes away. If I work as a court officer or a peace officer or a firefighter or anything like that, my employment goes away. I'm sorry, that's a violation of the Fifth. You're guaranteed the chance to face your accuser. You're guaranteed a fair trial. Mostly by the Sixth, mind you, but the Fifth sets up the foundations for those guarantees. Because at that point, in the case of that hearing, you are a witness against yourself because your guilt has already been assumed. I'm sorry, that's a violation of the Fourth and the Fifth right off the top. The last one I want to go over is that final clause in the Fifth that says, nor shall private property be taken for public use without just compensation. So we see the Bureau of Land Management seizing property and paying what they consider to be a fair price. The price should clearly be set by current land and property values, and the person has a right to say, no, you can't have my property. Sorry, pure and simple, that's the truth, and that's the way it should be. You also have the Safe Streets Law of 1995, which basically says that a state can have your vehicle impounded for as many as 30 days because you don't have a driver's license. Now, that's an infraction. To take somebody's personal property because of an infraction, I don't think it holds water in any legal statute. Now, I believe they should be fined. I believe you should have a driver's license. It's a law. It's a traffic violation, an infraction. It's not a misdemeanor or felony offense. It's an infraction. It's punishable by fines or community service. And people say that the Safe Streets laws don't provide use of the vehicles. Okay, one, while the state or the city rather has your car impounded, you're required to pay for that impound. So basically the state has taken your property, put it in someone else's hands, and told them you're going to pay for this. How does that not equal up to infringement? They're saying that you're guilty of something and they're going to make you do this. No, it's not right. Also, in many cases, these vehicles are seized, held in a police or private impound, and used for undercover operations, sting operations, things like that. And or they're being sold after you can't afford to get them out of impound. The city sells them for money to support your local police department or public service agencies. No, that's Fourth and Fifth right there. Boom, boom. Both being infringed on. It's not right. I do believe people should have a driver's license. I do believe people should follow traffic laws, but I don't believe their rights should be violated in any way, shape, or form beyond what those laws clearly dictate. Driving without a license is an infraction. I don't think your property should be taken and sold because you drive without a license. It's just not right. And I know people are going to say that, what if your license is taken because you're a drunk driver? Okay, yes, you're a drunk driver. Yes, you might be a jagoff, but you still have a family or responsibilities after you did something stupid that you deserve the right to be able to take care of. You deserve to be able to go to work. And people don't want to say there's a bus. Not always. I can personally tell you, having walked from Nanticoke, Pennsylvania to Pittston, Pennsylvania, and back every day for work, 27 miles, sometimes there's not a bus. Because in some places, the buses end at a certain time. My job didn't care about that. My job said, hey, I have to be at work. So if I had to drive, I had to drive. Now, I had a license, mind you. That's fine. But for people who didn't have a license, telling them they can't support themselves isn't right. But that's neither here nor there. It's a different topic. If you have any questions, feel free to ask in the comment section. We're happy to answer those questions. We appreciate you watching today. As always, be decent to each other. We're all in this together. God bless. Thanks for listening this week, folks. We really appreciate you. If you like that content, smash the like button and subscribe. If you want to help us get our message out there and grow this channel, please share our content. Again, we appreciate y'all. We hope you have a blessed day.